This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. This is Stuart Address for Ask a Lawyer. It's October 15th, 2021. We are in that last quarter of the year. A very important quarter because time is running out. Running out for what, you may ask? Running out for me being single. Tick tock, tick tock. All right, last week we had a caller. I begged for a caller so that my mother would not be the only one who had called the show. And I was obliged by several of you. The first one asked about, did I know anything about adhesion? And I was flummoxed, unsure of what he meant, and I admitted it. I said, no, I didn't. And after the show ended, it dawned on me, oh, I believe the caller was asking about contracts of adhesion, which is a subject that they teach us in the first year of law school. So if you are listening again today, call us back at 772-340-1590, and let's talk about the facts of what you wanted to discuss last week when it just did not connect in my brain. Because we're going to talk today about contracts of adhesion, because it really is an interesting topic, and it's one that is actually present in, I suspect, every single one of your lives in one way or another, and most likely in many, many, multiple ways over the years. So, what is a contract of adhesion? It's essentially one where you either have little or no opportunity to negotiate the terms of the contract. It is essentially a take it or leave it contract. Black's Law Dictionary defines contracts of adhesion in this manner. A contract that contains terms which consumers generally cannot negotiate. For example, the fine print, whose terms are usually to the advantage of the seller and which may be onerous. Okay? Where do we find these types of nasty contracts? You might be surprised. They are found in sources like Payday Loans, parking garages, valet parking, entertainment venues such as ballparks and stadiums, or even your local trampoline establishment, residential mortgages, insurance policies, credit card agreements, automobile purchase and leasing agreements. And every single time one of you clicks, I accept, to the terms of anything on the internet so that you can access a site or utilize a site. And you just click that button without reading anything that is in there. And I admit, I do it too. Why? Because we have no choice. It's not like we can contact the website and say, I'm willing to sign this, but please take out these 3 words. You either click I accept or you don't access the site. That is a contract of adhesion. But are all contracts of adhesion unfair and unenforceable? Or even if they are unfair, are they unenforceable? No, the answer is no. Now, there's another way to define contracts of adhesion that is similar but a bit more detailed. And it's been defined this way. An adhesion contract is an agreement where one party has substantially more power than the other in setting the terms of the contract. For a contract of adhesion to exist, the offeror must supply a customer with standard items and conditions that are identical to those offered to other customers. Those terms and conditions are non-negotiable, meaning the weaker party in the contract, usually us, must agree to the contract as it is, rather than requesting clauses be removed or changed. Adhesion contracts may also be referred to as boilerplate contracts. Now, I'm going to give you a really great example. In the olden days when you used to go into a car dealership and sit down to negotiate price and spend all those hours there, there was always something I tried to fight. That little pre-printed item that said something like, oh, delivery fee or dealers inherent profit or some crazy thing. And you'd see a number like $495, $795. And I would argue with them each time, that's part of your cost of doing business. I'm not paying for that. Take it out. And I'd always be told, we can't take it out. It's pre-printed. It's part of the contract. And so, well, me knowing how to negotiate, I say, okay, we'll leave it in, but deduct that amount of money from what you're making me buy the car at, or I'm walking away. And sometimes I'd win and sometimes I'd lose. But that particular line item never, ever came off the contract. Okay? It's boilerplate, and they wouldn't do it.
See, that's unlike my ESPN contracts that were made in invisible ink.
Greg says that's unlike his ESPN contracts in invisible ink. That's right. That invisible ink means they can say it says anything they want it to say whenever you have an issue.
Yes, they did.
I know what those types of agreements look like. I think I may have even written some when I was 6 or 7 years old, and I got this thing or majiggy in a bazooka bubble gum. I saved up all those wrappers or something. Remember those good old days?
Yeah, it didn't help that the guy that we negotiated with was a Marine who had like machine guns all over his office and stuff. Yeah, that was rather.
So while you were negotiating your contract at ESPN, you're telling me you're negotiating it with a Marine who has machine guns and all sorts of artillery in his office? I'd say that's pretty scary.
He was a scary individual. Actually, he's a good guy, but scary.
I don't think I'd be asking him to change a clause in my contract or give me any more money.
Well, he never gave more money, so that was a foregone conclusion.
All right, so let's look at a good example. I'm going to give you a couple of them to try to make the point. Payday loan stores. Oh my goodness. In the last few years in Florida, what a mess, what an uproar. Fortunately in Florida now, we have a statute that governs payday loans and how much can be charged in interest and all sorts of protections for the consumer. But before that happened, and in many other states, it's governed by what's called the common law. And the common law is really just a series of legal principles, legal doctrines that emanate from good old jolly England and that came with us as we came over and were colonies and then states. Now, let's bring it to modern times. A payday lender provides a short-term loan in exchange for a person's check and a fee. The lender agrees to hold your check for a period of time before depositing it. Now, in Florida, with the statute, that is now controlled by the Florida Office of Financial Regulations, Division of Consumer Finance. That is a mouthful. But before it was controlled, all sorts of shenanigans occurred. And I'm going to give you an illustration that occurred in Florida all the time, but the illustration I'm going to give you is from Delaware. In one litigated case in Delaware, the contract's terms called for a woman named, her last name was James, to make 26 biweekly interest-only payments of $60 in interest, followed by a 27th payment of $60 and the original principal amount of the loan, $200. The contract required her to pay $30 a week in interest. The total of the payments in a year for this $200 loan, $1,820.
No way.
Oh, very standard, very common. Clearly, that was a contract of adhesion, because who would ever agree to such a thing? Well, somebody who is desperate for an advance, who's living week to week and needs a little bit of cash, they'll take a payday loan. And these were the people who were most taken advantage of. So what happened in the James case? Well, Ms. James lost her job. As a result, she couldn't work, couldn't repay her loan, and had to default. When James and this company, National Financial, couldn't reach a settlement, she filed a lawsuit to rescind the loan, arguing it was a contract of adhesion and unenforceable. Now, we're going to talk a little later in a few minutes about the result of that case, but I want to give you another example. Let's turn to parking garages. We've all parked our car in one of these parking lots, either ones that have no attendants or have somebody in the front, giving you a ticket. And some of them have valet parking, or we'll pull up to a hotel or some other restaurant, they have valet parking. It's all similar. So how legitimate then is this management is not responsible for lost or stolen goods signs that you may see, or little print that's on the back of your receipt? Do these themselves release the management from responsibility? Or are they simply informing you of a legally established lack of responsibility? Let's look at some new words. I guess, I remember when I was a kid, I think Sesame Street and some of these other shows, they would give us new words of the day. Well, let's look at a couple new words. We're going to look at chattel, not cattle, chattel. And we're going to look at bailment. Has nothing to do with going to jail and getting bail. A chattel is a piece of personal property, like your wallet or the statue of Napoleon that you have in the trunk of your car. Why, I don't know, but you bought it at some, antique fair.
Have you been looking in my trunk?
I check it regularly to make sure that it's safe for human beings to drive or to travel in. Now, a bailment is a temporary relationship created when you transfer possession of a piece of chattel to another person, like a car with a valet. The car is the chattel, and transferring it to the valet creates a bailment. You, who is giving your car to the valet, you are the bailor. The valet, or the company whom he's employed by, is the bailee. Now, a bailment requires a certain level of care regarding your chattels, regarding your personal property. And remember, it doesn't have to be a car, and it doesn't have to be, a valet or a parking garage. This is just a principle. But what level of care do they have to take with your personal property? Well, that depends upon the state you live in. It depends upon whether that state has a statute, and it depends upon whether or not the state is governed by the common law or a statute.
What if they damage your car?
That's exactly what we're talking about. What responsibility do they have when that bailment was created and you entrusted your personal property, your car, to them? Well, the question Greg asked is, what if they damage your car? So another important piece of the puzzle is intent. Did you have an intent to create a bailment in the first place? Not every time you give a piece of personal property to somebody are you intending for them to take care of it. For example, in the 19th century and early 20th century, there was a whole flurry of legal cases where people would go shopping. In the 19th century, I don't believe they were in shopping malls, maybe in the 20th century. But people would go shopping. They'd put down an article of their own clothing, they'd lose it. And then they'd sue the store. Now, sometimes that worked, and sometimes it didn't. Nowadays, unless there is an intent to create a bailment, there is no liability. So in that situation, you put down your sweater to go into the dressing room, and then you come out and you forget your sweater. And you call up and they can't find your sweater anywhere, you sue them. You're going to lose. There was no intent to create a bailment. Now, what happens if you ask the salesperson in lingerie if she can hold your purse while you go in to try on something fun and frolic for your husband for a special weekend? I'm being a little sexist here, and I don't mean to be, but that's what's coming to mind. And you come out and you forget your purse. You just leave, and later on you call about that purse, and they don't know anything about it. That store may have liability, because when you ask the salesperson to watch your purse and the salesperson accepted possession and responsibility of your personal property, there may very well have been an intent on both parties, whether they realize it or not, to create what the law calls a bailment. let's look specifically at valet parking. You give your keys to an attendant, they park your car in some slot within the parking lot. After parking your car, the attendant gives you a claim ticket, and that allows you to reclaim your vehicle at a later time. That's a bailment. Now, what happens if on the back of that little ticket, it says not responsible for lost or stolen property? Most people have come to assume that it means exactly what it says, that you've agreed that they're not responsible, and if you come back and your car is damaged, stolen, has been keyed, and the security cameras have been down for 8 months and nobody's ever fixed them, well, tough luck on you. That's not true, though. In valet parking, you are turning your property over to the attendant, who is taking on the responsibility, even if the valet parking is free, of parking your car and taking a certain level of care for your property. Thus, they are probably responsible for theft or vandalism. What if you're parking your car on your own? It's one of these crazy monster parking lots where you go round and round, level by level, up, you go, you find a parking spot, you park, and you leave. The courts will very often consider that situation as different from valet parking, because there was no intent to create a bailment. You parked your car, and you probably bear the responsibility for theft or vandalism, unless, this is what got me into the law, the unlesses, the excepts, unless you can probably show negligence. But if there was no negligence on the part of whoever you gave your property to, if it just happened, and regardless of their efforts, their reasonable efforts to protect the security of your property, then they probably weren't responsible. But if they screwed up, they probably were. Let's give another great example, I think. Entertainment venues such as baseball parks, stadiums, or as I said before, your local trampoline establishment. Let's use the baseball parks as an illustration. Most of us who have ever gone to a baseball game know that on the back of that ticket, there is small print that says they are not responsible if you get hit by a foul ball and get hurt. I mean, we know it, we've heard it, we've heard announcers talk about it on baseball games on TV. Whenever somebody gets hurt, I've been at baseball games where line drives come screaming at you, and I've come pretty close a couple times. Never hit me, but I've seen people carted out on stretchers. What happens there? Well, let's look at an Idaho case. Roundtree versus Boise Baseball. A man sued a baseball stadium operator when he was struck by a foul ball and lost an eye while he sat in one of the few parts of the ballpark not protected by netting. Now, this is a more recent vintage. I'll call them the olden days, there was netting only behind catchers, home plate. Anywhere else in the park, there was no netting. And that's the way we wanted it, because we wanted a clear view. Then, for whatever reasons, often safety related, the netting was expanded to halfway down, let's say both sides of the field, the dugouts, and gave protection to people that were, let's say, halfway between home and third base and halfway between home and first base. And then the netting encroached a little bit further, all the way to the bases, first base and third base. And more recently, if you go to a ballpark, you will find netting that goes almost all the way to the end of where you will sit. There's maybe only a few sections out in the right field or left field that are not protected by netting.
Too many fans getting hit with 100-mile-an-hour foul balls.
That's right, 100-mile-an-hour foul ball. You know, these days, when I watch a ball game, the announcers report on what's called exit velocity. It's a statistic they like to look at. And that is when you hit the ball, how powerful did you hit it? Did it come off your bat at 87 miles an hour? Did it come off your bat at 106 miles an hour? You know, the faster that thing came off your bat, the harder it is if it hits somebody. And so in Roundtree, guy lost an eye. And he sues the Idaho, baseball operator. And the back of the ticket, just like I said, it had this language. The holder assumes all risks and dangers incidental to the game of baseball, including specifically, but not exclusively, the danger of being injured by a thrown or batted ball. And Mr. Roundtree said he never read it. Now, if you listen to this show for any period of time, you know how I feel about you didn't read it. It's most likely your problem now because you didn't read it. But with a contract of adhesion, why bother reading it? You got to live with it anyway. It's not like I can walk into the baseball stadium and say to the gate person that wants my ticket, please cross out these words, otherwise I'm not coming in. They call security and they'd escort me out. They don't have time to deal with that malarkey.
Okay, now that COVID has hit, there are no more printed tickets. It's all digital.
Greg is saying, now that COVID has hit, there are no more printed tickets. It's all digital. Well, it's probably on the digital receipt as well. Even whatever you print, there's something there, I guarantee you. It may be in 7-point type, what they really call fine print, but it's there. And so Roundtree sues. And in baseball, baseball is the only sport that has an antitrust exemption granted to it by Congress. And periodically, Congress has threatened to remove the antitrust exemption if baseball doesn't do X, Y, or Z. Well, in baseball, there had been a long-standing rule known as the baseball rule, which limited stadium owners and operators' legal duty to fans that were hit by foul balls. And so long as the screen seats are available for as many spectators as may reasonably request them on an ordinary occasion, baseball operators were not liable for the impact or injury caused by a foul ball. Now, that rule has begun to become eroded and in some cases no longer exists. The idea behind the rule seemed to make sense, particularly 50 years ago. The idea behind the rule was that it's common knowledge that baseballs are hard, they move fast, they travel beyond and outside the playing field. And so you are assuming the risk. Another wonderful legal doctrine. You are assuming the risk in the temporary relationship that is created when you choose to attend a baseball game. Well, as more and more people were injured, these provisions on the back of tickets were challenged. Are they really enforceable? And that is exactly where we're going, trust me, in just a couple of minutes. So let's see, this was okay. I had just lost my place here. Okay, we're back. We're back there. So as long as these stadium operators had provided the spectators with protection for as many spectators as would usually ask or want to be behind screening, they were okay. Now they've expanded this netting. I've said most these days, I think all baseball teams have expanded netting now to almost the end of the seating area. And they've done that despite fans complaining about it. We don't want no netting in front of us. We want to be able to see the field without all these little crisscross things in our way. I'll tell you something. I feel that way too. Now, I admit, when I go to a ball game, after 10 or 15 minutes, I sort of don't really see the netting anymore. You know, it's small enough and fine enough that, you know, your brain sort of makes believe it's not there, and you see the game just fine. But if you're a purist, you don't want that netting in front of you. And half the fun of going is the possibility of catching a foul ball. Now, of course, you know, a foul ball that comes screaming at you at 100 miles an hour is probably going to break my skull, and I'm not going to catch it. You know, maybe a 12-year-old might, who's been playing Little League and has the reflexes of a 12-year-old, but not me. Now, if it's a pop fly, you know, I'll dive for it like anybody else. But that's not what they're worried about. They're worried about these screamers. So in the case we had been talking about in Idaho, the court wrote that the litigants had presented evidence of so few instances of similar injuries that they could not draw, the court could not draw a bright line as to where the stadium's duty began or where netting should be placed. So the court left it to a jury to decide the reasonableness of each party based upon the facts in that particular case. Now, regarding the ticket disclaimer language, the court refused to enforce it as a contract against Mr. Roundtree, even though it had all the necessary elements: a valid contract, an offer, acceptance, consideration. Instead, consistent with the court's general disfavor of contracts of adhesion, the Idaho court decided that the jury should consider the ticket language when deciding what percentage of Mr. Roundtree's injuries were his own fault, assumption of the risk. So you can see here how it's not black and white. There are things that courts have to consider in trying to decide the level of liability, but it's not black and white in favor of the other party who wrote this contract either, which is what they wanted and what they had for so long. So let's go back to that James case. Remember, I was talking about the Payday case. let's go back to that case now that we've sort of discussed some of the parameters a little bit. And let's talk about contracts of adhesion and to what extent they're enforceable and to what extent they're unenforceable. Now, the general rule that is accepted in most jurisdictions is that a contract of adhesion is valid and fully enforceable unless it's unconscionable to the party that is creating the bailment. In other words, giving over its possession, even if it's giving over its possession like you to a ballpark. Unconscionability is an elusive term. What is unconscionable? What offends the conscience? Man, particularly in today's political environment, that is going to be radically different depending upon who you've got on a jury. What offends the conscience?
What if
I don't know if it's ever been more polarized as to who might think something offends the conscience and who doesn't.
Sure. What if you order something on the internet that doesn't show?
Well, if you order something on the internet and it doesn't show, you're not really dealing with a contract of adhesion, you're dealing with a breach of contract. So presumably, you get your money back. And you know, like vendors like Amazon, who are so big and they don't want to lose business, they'll routinely, you know, refund your money because it works better for their business model. So how do we figure out what's unconscionable? How do the courts figure it out? Well, there are some guidelines. There are some guardrails that help us stay within the lines to some extent. Was there an extreme inequality in the bargaining position or the economic power between the two parties? Well, you know, if I'm parking my car in this parking garage and, you know, this place owns 500 parking garages and is a multi-million-dollar industry, I don't have much power. Now, it's a mom and pop place that owns this one little piece of dirt that happens to be near a stadium. Maybe you can make a deal, but not these commercial establishments. What is the phrasing in the contract? What language does it use? Would a non-lawyer be expected to understand it? Was there in the contract any exploitation of underprivileged, unsophisticated, uneducated, or the illiterate? There are situations, for example, with payday loans, where somebody who spoke and read only Spanish would be presented with these loan papers in English and be told to sign it. And everybody knew that they didn't understand what they were signing. Is there an imbalance in the contract in terms of the obligations imposed? Is it a one-way deal? And are there contract provisions that are inconsistent with the signing party's reasonable expectations? These are all things that the court will look at or a jury will look at when you argue, A, that we're dealing with a contract of adhesion, and that B, if it is a contract of adhesion, it should be an unenforceable contract of adhesion, because not all contract of adhesions are created equally. They are not all unconscionable. So there's a 2016 case of James versus National Financial, which we mentioned. And remember the plaintiff, Gloria James. She was a part-time housekeeper at a local hotel. And she had dropped out of high school and had neither a savings account nor a checking account. And to make ends meet, she signed an agreement for a $200 consumer loan that was a standardized boilerplate contract that was given to her on a take it or leave it basis. And a day after getting the loan, she broke her hand while working. She lost her job. And as a result, she could not repay her loan and she defaulted. And when the parties couldn't resolve the issue, James filed a lawsuit to rescind, cancel the loan. And the Delaware court agreed with James and held that the loan agreement, a standard adhesion contract, could not be enforced because it was fundamentally unfair. It shocked the conscience. It was unconscionable. First, the court said, there was an inequality of bargaining power because the loan company and the plaintiff, James, didn't negotiate over the terms of the loan. It was a standardized boilerplate, take it or leave it. Second, the loan agreement could not easily be understood by a non-lawyer. It was 6 pages long, and the first 5 pages had important financial terms that required a level of sophistication that wasn't possessed by the plaintiff and would not be expected to be possessed by the normal consumer of a payday loan store. And finally, third, the obligations had an overall imbalance because of the 838% annual percentage rate, which is what it worked out to. The court said that shocked the conscience. And so that contract of adhesion was deemed unenforceable. The loan was rescinded, and it was the establishment who owed money to Mrs. James because of all that interest she had been paying. She had long since paid the $200 plus a reasonable level of interest that was enforceable.
Aren't there usury laws? Usury laws?
Usury laws, absolutely. Usury laws are laws that limit the maximum interest rate that can be charged. Most states now have usury statutes, and they limit the maximum rate in various contexts. For example, the maximum rate for credit card companies might be one rate. The maximum rate for payday loans may be a higher rate. Not an unfair, exorbitant rate, but a higher rate because of the risk being taken by payday loan companies of default. Since they have a higher risk, generally state legislatures have determined they're entitled to a higher reward, a higher interest rate. So really, for usury in terms of interest rate issues, you try to look at a state statute. And if it's above the statutory rate, the interest rate, at least to the extent above, is unenforceable. And there may be other consequences to the fact that the party making the loan charged you a usurious interest rate. So let's look at a Florida case from 2014, Florida Supreme Court. Case is Salto versus Hialeah Automotive. And a 5-2 majority of the Florida Supreme Court held arbitration clauses contained in various agreements signed by Spanish-speaking plaintiffs relating to their purchases of Dodge Caravans were unenforceable. The Florida Supreme Court upheld a trial court's ruling that these clauses, these arbitration clauses, could not be enforced because they were unconscionable. Now, the plaintiffs who had taken out loans, they were a married company, they were a married couple from Cuba who did not speak English. They purchased a 2005 Dodge Caravan from Hialeah Automotive in 2004. And when they purchased the vehicle, they signed all sorts of paperwork in English. Now, if any of us have ever bought a car, we know the volume of paperwork that we have to sign, initial, etc., etc. Later, there was a dispute between the parties when the Basaltos tried to return the vehicle to Hialeah Automotive. And I don't know the details of why they are returning the vehicle, whether they were justified or not justified. I know that there was a dispute. And the dealership tried to enforce the arbitration provision and send the matter to arbitration. Whereas the Basaltos said, no, we want to litigate it in a court in front of a jury. Now, we all know that the essence of our system of justice are jury trials. But you also should know that courts everywhere have held that arbitration provisions are highly, highly favored, and they are enforced unless they are unfair. And why do courts look at arbitration clauses as highly favored? Because it gets the matter out of the court system, which is already overwhelmed and clogged. So if you sign an agreement that has an arbitration clause, the chances are you're going to arbitration. But here, that wasn't the case. Now, the Florida Supreme Court determined that as a result of the language barrier and the fact that the documents were in English, that it was unconscionable to bind the Basaltos to the arbitration clause. The court looked at what was called procedural unconscionability, which is concerned with the manner in which contract is entered into, and substantive unconscionability, which focuses on the fairness of the terms. Now, what are the lessons from the case? Often, the party with leverage uses that leverage and that power to insert unfair and unconscionable terms into a contract. And the party, the weaker party, ends up either accepting the loss because they believe that this provision is enforceable and they don't fight it, or they fight it, and depending upon the facts, they can win or they lose. What you should take from it, I think, is that in any situation where the argument on the other side is, well, you signed this, and your reaction is, well, that was unfair, you should ask a lawyer. You might be wrong, and the lawyer may tell you, as I have told many, many prospective clients, I'm sorry, I know that may have been a little unfair, but you know, that's not going to be unenforceable in court, in my view. But I've also told plenty of people, that's incredible. I can't believe that. Is that in writing? Email it to me, because I want to see it for myself. And if I see it, then I really believe it, and I might decide this is worth representing an individual. So don't just assume that the other side has you over a barrel. I'll use that analogy instead of another one, which would have been a little bit more graphic. If you believe you've been treated unfairly in this regard by a term in a contract, or on a ticket, or on a receipt, or what have you, where they're trying to enforce something against you, at least make a call to a lawyer. It doesn't cost you anything other than a few minutes of your time. And you might find out that the lawyer is willing to represent you, oftentimes on a contingency basis, where you don't have to pay the lawyer anything unless you get money. Why are lawyers willing to do that? Because oftentimes there are statutes that provide for attorney's fees if you win. And so the lawyer knows that this big giant company may be responsible for the attorney's fees. And so you may get your $300 value of your lost purse. The lawyer may get $30,000 depending upon how long and how hard the company fought it. And that's why you should check with a lawyer. They may represent you even in these small little cases. To me, I guess that's one of the most important principles as we're running out of time. One of the most important principles I would take. We get calls in the office where, my paralegal or my assistant may take the initial call and get the basic facts, a screening, and then come to me. And I may not even have to ask for any more follow-up. I may just say, that's absurd. There's no claim there. Just call the person and say, we're unable to handle it. And that happens. It happens a lot. But it also happens that my paralegal will come to me, oh, I have to leave, and say, I don't think there's a case here. And I'll listen to the facts and I'll say, oh, no. Au contraire. Get that person in here. So it's time for me to say goodbye, and I will. Hope you found this interesting. Have a good weekend. Have a good week. And I'll be back next Friday with Ask a Lawyer.
WPSL, WSTU.